and gentlemen, welcome back to the conference. Thank you so much for joining us. So we're now transitioning into our afternoon session, entry into force of the 2019 Judgments Convention, starting with a keynote speech on the topic of the 2019 Judgments Convention, a game changer in transnational litigation, by the Honorable Justice David Goddard, Judge of the High Court and Court of Appeal of New Zealand. So now Justice Goddard is joining us online. Let's give a warm virtual welcome to him. Hello, Justice Goddard. Hello.
Good afternoon.
Good afternoon. Yes, we can hear you very clearly. So now the stage is yours. Please take your time.
Thank you very much. Well, good afternoon, distinguished participants, old friends. I think the Secretary General slightly blurry in the front row. Good afternoon, Christophe. I hope you're less blurry in real life than you are on my screen. It's a really great pleasure to be speaking at this HCCH Asia Pacific Week event. I'm just sorry I can't be with you in Hong Kong, but I'm sitting on a couple of appeals this week here in Wellington. I'm going to provide an overview about the 2019 Judgments Convention and its significance. I would say its great significance globally and for our region, and to talk a little bit about how it came to pass. Others are then going to talk about it in more detail. So that's my excuse for being a little superficial on the fine details this evening in the limited time. Anyway, the Judgments Project was in the room from 1999 to 2019, 20 years. I had the privilege and pleasure of being a member of the drafting committee for the Choice of Court Convention. I'll talk in a moment about how that fits in. And chairing the negotiations on the text of the convention in July 2019, just a little over 4 years ago. I'm enormously proud of what we collectively achieved in 2019, and I'm delighted that that success is reflected in such a swift coming into force of the convention, materially faster than the average, I think, over the history of the HCCH. It reflects an understanding, a global understanding of its practical relevance and importance, through working hard at consensus, through listening to each other, talking, thinking, and finding a text that we could all endorse as already in force, excitingly, and I think with significant momentum towards widespread accession. I'll talk now a little bit about the project, so if we could go on to the slide headed the Judgments Project and Overview. And then continue on. Set out to achieve, really from the beginning, back in the 1990s, but ever more sharply in focus as our work continued. The objectives were twofold: enhancing access to justice, enhancing access to practical justice, justice that's effective across borders, and facilitating cross-border trade and investment by reducing the costs and risks associated with cross-border dealings. As I'm sure many of you know, there was an initial very ambitious proposal back in the 1990s for a mixed convention that would deal with both jurisdiction and enforcement of judgments. But that encountered some difficulties precisely because of its ambition, and as is often the way when you're trying to solve a whole lot of problems together, the ones that were hard occupied most of the oxygen, to the exclusion of the things that we were actually able to achieve. So, from 2001 onwards, we decided to take a more focused approach to build the globe from the inner layer outwards, rather than trying to solve the whole thing all at once. And that was a very rewarding approach. We were able to pretty swiftly conclude the Choice of Court Convention in 2005. That's been enforced since 2015 and has more than 30 contracting states and the EU as parties, all the EU states, Singapore in our region, the UK. It's been signed by China, by the United States, and other instruments. Its focus is on exclusive choice of court agreements, giving effect to those agreements and recognising and enforcing the judgments given by the chosen court. It can be thought of as a court-based equivalent to the very successful New York Convention on Recognition and Enforcement of Arbitral Awards. And then the convention that's the focus of this afternoon's discussion, the Judgments Convention, which, as I said, we completed July 2019, in force. Can't say this too often, really, can we, Secretary General? In force since 1 September this year. So if we turn over to the slide on the status of the Judgments Convention, I say it again because it's just such an important thing. This convention has been in force since 1 September this year, just over 4 years since the text was concluded. It's in force for the EU and the EU member states other than Denmark and for Ukraine. In addition, it's been ratified by Uruguay and it will be in force for Uruguay from the 1st of October 2024. There are, I think, currently 6 additional states that have signed the convention, and I'm aware of a number of others that are actively considering how best to proceed towards becoming parties to this important instrument. So, what are its key features? If we go over to the next slide, please, get a Judgments Convention key features. Well, it provides for recognition and enforcement of judgments in civil or commercial matters. It doesn't contain provisions in relation to direct jurisdiction. It doesn't provide for which court will hear particular proceedings, and it doesn't deal with the issue of parallel proceedings. So if you have parallel proceedings in 2 states, the convention doesn't attempt to regulate that. There's work happening elsewhere and another project on some of these issues, and that's going to be addressed later on. It applies to final judgments of a court. It includes non-money judgments. That's important because traditionally most cross-border enforcement of judgments has been confined to money judgments. Recognition's been broader, enforcement money judgments. But we now have many years of experience of enforcing arbitral awards that may provide for non-monetary relief, that order specific performance, that grant injunctions. And it is timely, I would say overdue, to make appropriate provision for the recognition and enforcement of non-money judgments from courts. It includes default judgments, and it excludes, very importantly, interim measures of protection. We had a conversation about that and concluded relatively quickly that it was most appropriate for each state to decide whether and how it would grant interim relief in support of proceedings in other states, rather than attempt to have interim orders travel under the umbrella of this convention. Importantly, the convention is facilitative. It doesn't prevent states recognising and enforcing judgments to which the convention doesn't apply. It doesn't prevent states from entering into arrangements for enhanced cooperation, as for example, between my country, New Zealand, and Australia. National law can provide for more extensive recognition and enforcement. There's one detailed exception to that, which I suspect might be touched on later, in relation to judgments concerning rights in rem in immovable property, except where the judgments of that kind don't circulate unless the property is situated in the state of origin. But with that one rather narrow exception, reflecting a very traditional approach to which court is appropriate to determine matters of that kind, it is open to national law to provide for more extensive recognition and enforcement of foreign judgments. We go over to the next slide, Judgments Convention, Key Features, Cont. And I'm sorry you're having to get these audio audio directions, but we were experimenting with screen sharing earlier this evening and ran into some unexpected hiccups. So I'm dependent on the kind support of the team in the room, which is doing such a great job, I'm sure. So, yes, big thumbs up, it's all happening. Thank you, Edwin and others, that's really great. So, certain matters are excluded from the scope of the convention, including three broad categories. Certain matters that are addressed by other international frameworks, other international regimes, for example, maintenance, insolvency, carriage of passengers and goods, and certain maritime matters. Then there were certain matters of particular sensitivity, for example, judgments in defamation proceedings, judgments in privacy proceedings, judgments in antitrust or competition proceedings, although there's an exception there for hardcore cartels, which we were all able to agree were seen as problematic and should, where consequences followed from such cartels, be enforceable globally. These were areas where different states strike different balances, and it was found to be too difficult to provide for recognition and enforcement of judgments without cutting across some of those differences of approach. And finally, matters that need further work or time, in particular intellectual property matters. We explored intensively and over an extended period whether we could provide for some intellectual property judgments to be recognised and enforced under this instrument. And really my one regret in relation to what we achieved in 2019 is that we weren't able to get there. I thought that was within grasp, but ultimately, in the time available, and despite a great deal of goodwill, we just couldn't land it. And we made the pragmatic choice, consistent with the overall approach, that we would do the things we could do rather than let the perfect be the enemy of the really very good. So, we parked intellectual property for the time being. I would like to see a return to that topic, perhaps in collaboration with LIPO at some stage to find a path through these difficulties, which I am confident does exist. Anyway, sorry, that's one of the B's in my book. We'll get back to that. We'll solve that problem one day. I have a protocol envisaged in my mind already. And I'm sure we can make it something very practical, very workable with everyone's insight and collaboration. Anyway, the Judgment Convention goes on to provide for specified grounds for recognition or enforcement of judgments, sometimes referred to during our discussions as the jurisdictional filters. These are connections between the state of origin, the state where the judgment was given, and the parties or the claim. Connections that mean that the person against whom recognition or enforcement is sought cannot reasonably say, I should not be bound by the judgment from that state, because there's a sufficient connection. If those filters are scope, and if there is one of the necessary connections between the state of origin, the court of origin, and the proceedings in which the judgment was entered, then there are limited grounds for refusal of recognition or enforcement. It says, well, at this point, there are only limited circumstances in which recognition or enforcement can be refused, and these will be discussed by others. They're the very familiar private international law grounds for declining recognition or enforcement of a judgment obtained by fraud. There are concerns about natural justice, public policy, about service, these matters. Critically, there's no review on the merits. The court in which recognition or enforcement is sought does not go back into the merits of the underlying dispute. There are declaration regimes to manage a number of sensitivities that were identified in the course of our negotiations. These are regimes that enable a contracting state to put certain matters outside the scope of its obligation to recognise and enforce judgments from other contracting states. The state can make a declaration with respect to specific matters, specific topics, and put judgments on those topics out of scope for it, and vice versa, its judgments on those topics also will not circulate. And for certain matters relating to governments, to deal with different approaches to litigation against governments. Finally, there's a notification process that applies where a state becomes a party. A state that becomes a party can identify any states that are already contracting states with which it doesn't want to enter into treaty relations, and conversely, existing states can, within the 1-year window before the convention comes into force, the newly acceding state decline to recognise and enforce its judgments if there's good reason to do so. Again, this was a protection that some thought it was prudent to provide because it will give states comfort that they can accede to the convention without writing a blank cheque to enter into relations with any future state at any time. I am rather doubtful that this will be used much or at all, but it's important reassurance. It makes it easier to join knowing that the safety valve is there in the unlikely event it's required. But like having a parachute under the seat in your plane, I suppose it provides some reassurance, even though you really hope you're never going to have to go fishing under the seat and try to work out just how it was that the flight attendant put it on. Anyway, and I don't, certainly never had to look for one of those under a seat. Some of these are a bit like that. Anyway, the parachutes are there if required. Moving on to the next slide, I thought I'd touch briefly in the remaining minutes available on the relationship between the Choice of Court and Judgments Convention and how I see things playing out in the future. So if we go to the slide that says relationship between Choice of Court and Judgments Conventions. Got that? Great. So these are complementary, they're sister conventions, they're designed to work together. And the expectation, I think, of all of us who worked on framing judgments is that they will work best together. They'll work best where states become parties to both and they operate in tandem. Even in the choice of court space, judgments is important because choice of court is only concerned with exclusive choice of court agreements, and a very common, very important type of cross-border transaction is financial transactions of various kinds. And those usually contain non-exclusive choice of court provisions, and what that means is that the Judgments Convention will be the relevant one for them. I am confident, looking at this package, that the two conventions together will significantly advance those goals that we set out with at the beginning, the goals of enhancing access to justice, the goal of facilitating cross-border trade and investment. And there are four main ways in which these goals are advanced, I think. The first, and it's obvious, but it's worth noting, is the enhanced practical effectiveness of judgments, which means enhanced practical justice across borders. Justice that produces results, not just a judgment on paper that can't be given practical effect. Second, there will be many situations in which these conventions will avoid the need for duplicative proceedings, for bringing essentially the same claim in a second or third or fourth state. Rather, judgment will be obtained in one contracting state, which resolves the issue effectively between the parties, and it will then circulate without the need to file new proceedings and deal with the merits again. Third, and very importantly, the convention, and I think especially judgments actually, but both together, improve the accessibility of law in this field. It's a very complicated matter, as those of you will know who are engaged in transnational litigation will know, to work out whether a judgment obtained in one state will be recognised and enforced in states B, C, and D. You need to get legal advice in each of those. The results may be different. The transparency created by having this convention, the ability to look at it and say, well, I know it's a contracting state. I know what the ground rules are. I know whether the state is a state of origin whose judgment will be widely recognised and enforced, and I know the conditions under which it will be recognised and enforced. This is a huge advance in the accessibility of the law and the certainty and clarity of law in this field. And that, I think, is one of the major attractions of these conventions. Even if they just wrote down the law as it stood now and made it more accessible, I think that would be a large gain. They don't just do that, they achieve a number of practical improvements, but it would be wrong, certain, clear. And fourth, I've already hinted at this before, the convention facilitates informed choices being made about where to bring proceedings in the first place. Not because it regulates this, especially judgments, choice of court does, but not judgments, because you will know whether you're bringing proceedings in a contracting stage, you will know where the convention, the judgment that's obtained will be circulated. So, that's a lightning fast tour through the history of the conventions and broadly how they work to answer those goals of enhancing access to justice and facilitating cross-border trade and investment. I'm confident they'll be widely ratified in coming years. The momentum that they already have is significant. Continue to explain the benefits of these instruments and encouraging their adoption in New Zealand. I'm sure that many others will be explaining their benefits and encouraging accession in their jurisdiction as well, which is short on multilateral instruments providing basic legal infrastructure of this kind. Contributions huge. It's true globally. I look forward to future. I put up that status slide at the beginning.
All right.
When I talk about this, the numbers of contracting state dramatically. Thank you.
Thank you very much. You left a very lovely picture on the screen. Thank you so much, Justice Goddard. Thank you for joining us this afternoon. And please stay connected with us. We probably will have a Q&A session afterwards. Thank you very much. Now, following, we are going to invite to stage Professor Yuko Nishitani of the Kyoto University of Japan. Welcome to stage and have a seat. And let's also welcome Professor Fernando Diaz Simoes, Associate Professor of Law at Louisiana University of Porto and Portucalense University in Portugal. Welcome to stage. And Dr. Jacek Kowalski, partner of Kochanski and Partners in Poland. Please come on stage and have a seat. Thank you very much, ladies and gentlemen. Okay, meanwhile, let's firstly have Professor Yuko Nishitani to give a speech on the topic of Introduction to the 2019 Judgments Convention, History, Text, and Impact. Please come to the podium. Thank you very much.
Thank you very much. Thank you very much for this kind introduction. Ladies and gentlemen, it's a great pleasure to give a talk at this Asia Pacific Week of the Hague Conference on Private International Law. And I sincerely thank Dr. Bernasconi and Professor Go Eschkola for your warm and kind invitation. So my task is to talk about history, text, and the impact of the 2019 Judgments Convention. But David has actually covered many points, so I try to cut short and to avoid overlaps. 2019 Judgments Convention is an instrument for judicial cooperation for the global circulation of judgments. And it seeks to enhance access to justice and facilitate trade and investment. Both are covered by SDGs of the United Nations. And it has just entered into force, which is a great pleasure for us. And we hope that more and more countries will join this instrument. The importance of the recognition and enforcement of judgments has been stressed from early on, from the 19th century. And there have been also several preceding HCCH instruments from 1958. And the original judgments project was initiated in 1992 to adopt a mixed convention at the time. And then due to several difficulties, it was reduced to the choice of court agreement convention, which was adopted in 2005. And this convention has entered into force on the 1st of October 2015, has attracted 33 contracting parties, and 4 states have signed so far. The choice of court convention itself is a double convention. So it regulates both the direct jurisdiction based on the exclusive choice of court agreement and the recognition of enforcement of judgments rendered by the chosen court. And all the other states are supposed to cooperate. So when state A has been chosen by the parties exclusively, but one party seizes the court in state B, then the state B, in principle, is supposed to dismiss the claim because it does not have competence to hear the case, in principle. And once the court in state A renders a judgment, then it is supposed to circulate among contracting states. So that's a double convention that regulates both direct jurisdiction and the recognition and enforcement of judgments. After the choice of court agreement convention was adopted in 2005, and the Permanent Bureau started to work on further on the judgments project, and it was in 2011 that the Council gave the green light to reconsider the feasibility of an instrument on jurisdiction and recognition and enforcement of foreign judgments. And in 2012, the expert group approved further work, and the working group was convened and prepared a draft convention. And after that, from 2016, 4 special commission meetings were held until the judgments convention was adopted in 2019, and it has entered into force 1st of September this year. The convention has attracted already 29 contracting parties, namely EU and member states except Denmark, Ukraine, and Uruguay will be also the party to the convention, and the convention will enter into force there. And 6 further states have signed this convention as well. The objective and framework of this convention. So this convention seeks judicial cooperation and promote access to justice and facilitate trade and investment. And with this instrument, the predictability and certainty on the circulation of the judgments ought to be achieved. And this judgment convention is a single convention because it does not deal with direct jurisdiction, but only with the recognition and enforcement of judgments. As David mentioned, the Judgments Convention has a 2-tier system with the 2005 Choice of Court Convention. And an important point of the Judgments Convention is also that it has the principle of non-exclusivity. Namely, national law remains applicable in favor of recognition. So the contracting state has a choice of recognizing a foreign judgment coming from another contracting state, either under the convention or under the national law, in principle, except for the exclusive jurisdiction rules under Article 6. The scope of application of the Judgments Convention is crucial, and it has several excluded matters that can be categorized into 3 different groups. So the first one is are the issues that are covered by other instruments like status and family matters, insolvency, and carriage of passengers and goods. The second categories of excluded matters are rather sensitive issues where countries had difficulties agreeing on having uniform rules in the convention. So they are defamation and privacy, because they are closely related with the constitutional principle of the freedom of speech, and where to draw the line between the freedom of speech and defamation is a very sensitive issue in different states. So the US, for example, has a specific rule in that respect. The EU Rome II regulation had to exclude defamation and privacy for that reason. So this is why the Judgments Convention does not touch upon this issue. Intellectual property is also a sensitive issue because a lot of states have large economic interest in intellectual property nowadays. And the intellectual property rights are governed by the principle of territoriality. So this is why when a judgment comes from a foreign country, it is not easy to judge whether the territoriality principle is observed or not. So this is also the reason why intellectual property has unfortunately been excluded. Antitrust or competition is also a difficult issue. So this is why the Judgments Convention excludes public enforcement issues regarding antitrust. But as we will see, private enforcement measures with regard to cartels are included in this convention. So third category of excluded matters seek clarification. So particularly acts of states like activities of armed forces and law enforcement are explicitly excluded to clarify the interpretation. And then Judgments Convention also seeks not to interfere with arbitration and related proceedings. So this is why these matters are also excluded from the scope. And the Judgments Convention is a two-tier system with a 2005 Choice of Court Convention, but there are certain points where the Judgment Convention deviates from the 2005 Convention. So particularly the scope has been extended in the 2019 Judgments Convention. So consumer and employment contracts that have been excluded in the 2005 Convention have been included in 2019 Convention. And also personal injury and infringement of tangible property are included in the Judgments Convention. And rights in rem in immovable property or tenancy of immovable property are also included. And in addition to that, private enforcement measures in antitrust law are also included in the Judgments Convention. So in that respect, while the 2005 Choice of Court Convention was envisaging commercial disputes, the scope of the Judgments Convention of 2019 has been extended to civil matters in general, so to say. One of the important points of the Judgments Convention is jurisdictional filters. So jurisdictional filters are positive conditions that have to be fulfilled in order that foreign judgments can be recognized and enforced. There are several jurisdictional filters in the convention, and if one jurisdictional filter is met, it is sufficient, except for exclusive jurisdiction ground in Article 6 and Article 5.3. But for other matters, usually it is sufficient that one jurisdictional filter is met. And because jurisdictional filters are positive conditions, they must be fulfilled, and the burden of proof that the jurisdictional filter is met ought to be fulfilled by the person seeking the recognition and enforcement of the judgments. So it's not explicitly mentioned in the convention, but from the structure, the usual procedure would be that the person seeking recognition and enforcement of judgment would have to prove that one of the jurisdictional filters is met. Jurisdictional filters can be categorized into 5 different groups. So I'd like to pick up several important points because of the limited time. So the first category concerns jurisdictional filters based on personal ties with the forum state where the judgment is rendered. So first, the defendant's habitual residence or principal place of business for natural persons are the jurisdictional filters. And in the case of companies, the habitual residence is defined broadly in the convention, so it includes the principal place of business and the place of incorporation and place of administration and so on. So there are 4 definitions for the habitual residence of a company. Another personal ties with the forum is given by the defendant's branch office And insofar as a case is related to the activities of that branch office, then that jurisdiction is also considered as a sufficient connection for the judgment to be recognized in the requested state. The third point is that recognition and enforcement of judgments is sought against plaintiffs. So plaintiff in the original proceedings is someone who chose the forum state himself. So this is why it is considered as a sufficient connection to fulfill jurisdictional filters. The second categories of the jurisdictional filters are based on specific subject matters. So the first one is for contractual obligations. The place of performance is the jurisdictional filter. I'd like to see it more in detail later on. And other subject matter jurisdictions are tenancy or security interest in immovable property, and the place where the immovable property is situated is granted jurisdiction. And for personal injury and infringement of tangible property, the place where the action took place has jurisdiction. So it explicitly excludes the place where the damage occurs. So there are complex kind of tort where the action takes place in one state and the damage is felt in another state. And the damage can be felt in different countries, particularly for product liability cases or environmental damages and so on. So the place where the damage occurs is explicitly excluded as jurisdictional filters, and only the place of action counts as jurisdictional filters. And for internal aspects of trust, they have also a specific rule for the designated forum or principal place of administration. So for contractual obligations, place of performance jurisdiction is provided, and it is not an easy task how to define the place of performance. The convention says that, first of all, the place of performance is either explicitly or impliedly agreed by the parties as the place of performance, or the place of performance determined by the applicable law. So I'd like to give you an example where one party habitually resident in state A is a construction company and signs a contract with another company habitually resident in state B. And let's suppose that the company located in state A agrees to build a building in state B, and all the work has been done, but the company that ordered the construction of the building did not pay the money. And suppose these parties did not specify the place of performance for the payment of money, but they chose Japanese law. So in such a case, the Japanese law determines the place of performance for the payment of money where the creditor is located. So this is why, under this example, the place for the payment of money will be in state A. So this is why when the construction company institutes proceedings in state A against the company that ordered the construction of the building and seeks the payment of money, then the judgments can be rendered in state A. And the question arises whether this fulfills the jurisdictional filter under the convention or not. And the place of performance itself is under Japanese law, state A. But in addition to that, the convention has also specific safeguards, which says that the place of performance must have purposeful and substantial connection with the case. So this is in light of the US and Canadian rules that require to give jurisdiction to the place of performance, in addition, a purposeful and substantial connection. So this is why in this case, the state A's jurisdictional filter can only be fulfilled if the defendant has been doing business continuously and had continuous activities in state A. So this safeguard must be met to fulfill the jurisdictional filters. Other jurisdictional filters are based on agreed or accepted jurisdiction. So submission by the defendant can also fulfill the jurisdictional filter. And advance, so non-exclusive choice of court agreement made before the institution of the court proceedings can also give a jurisdictional filter in this case. For consumer and employment contracts, the convention specifically has a particular jurisdictional filter and excludes party autonomy because in consumer or employment contracts, the weaker party shall be protected when the recognition and enforcement of judgment is sought against consumers or employees. So this is why the jurisdiction is granted where the weaker party has habitual residence, but the consent given by the defendant must be explicitly addressed to the court. And the other kinds of jurisdiction based on party autonomy are excluded to protect the weaker party. The fifth and most important jurisdictional filter is the exclusive jurisdiction that concerns rights in rem in immovable property. So for example, if an ownership of immovable property is disputed between the parties, then the exclusive jurisdiction is given to the place where the immovable property is located. So actually, comparatively speaking, most countries have exclusive jurisdiction for rights in rem immovable property where the asset is located, but Japan is an exception that we do not grant exclusive jurisdiction, but accept also jurisdiction in other countries. So for example, if the disputing parties are domiciled in state A, which is Japan, but the immovable property is located in state B, then Japanese courts may exercise jurisdiction and render a judgment in Japan. This is because to facilitate the dispute resolution between the parties domiciled in state A, but if Japan becomes a member state of the convention and state B is also a convention contracting state, then the judgments rendered by Japanese courts may never be recognized and enforced in other contracting states because there is an exclusive jurisdictional filter for state B. This is actually the current situation already, and even if Japan does become a member state of the convention, that does not change a lot, but still it's important to note that the convention has exclusive jurisdiction in favor of the immovable property for rights in rem disputes. In addition to jurisdictional filters that are positive conditions that need to be fulfilled, there are also grounds for refusal for negative conditions. For in cases where the recognition of judgments may infringe, for example, the public policy of the recognizing state, or there was no proper service of the document, then the recognition and enforcement of the judgments can be refused. An interesting provision is about pending proceedings. So there can be a situation where parallel proceedings are pending between state A and state B, between the same parties on the same subject matter, and state A first renders a judgment. And the question arises whether state B ought to recognize and enforce the judgments or not. And the convention says that when the court proceedings in state B started first, earlier than in state A, and there is a close connection between the case and state B, then state B can postpone or refuse the recognition and enforcement of the judgments coming from state A. So that is also a specific rule that gives clarity to the cases where judgments can be refused to be recognized. The possible impact of the Judgments Convention is I think, as David said, it's very positive, I think. So the jurisdictional filters are quite reasonable, and grounds for refusals give flexibility because it's discretionary grounds. So the recognizing state can decide to use the grounds for refusal or not. So that it gives enough leeway for the recognizing state to decide whether or not to recognize the foreign judgments. And as we saw about the scope of the convention itself is mindful of protecting state interests and policy. And because national law remains applicable, there is also flexibility for the recognizing state either to choose recognizing the foreign judgment under the convention or the national law. And there is also opt-out mechanisms for establishing the treaty relations in relation to certain states. So if a state becoming a party of the convention has certain concern in relation to certain states, then they can opt out and reserve creating a treaty relations with certain states. And that gives a cautious safeguard towards certain states. The convention itself enhances legal certainty and predictability, and that will certainly facilitate using litigations also for small and medium-sized disputes. And having global uniform rules will be very useful to establish a better system of recognition and enforcement of judgments. And ensuring reciprocity is actually very important in Asia Pacific because particularly between mainland China and Japan, there is no judgments recognition because our courts have said, unfortunately, mutually, that there is no reciprocity with other states. So this is why commercial disputes between China and Japan need to go to arbitration to have cross-border effects. And China itself has 35 bilateral treaties with different countries, and reciprocity has also been gradually established with South Korea, Singapore, Australia, the US and the UK, and so on. So we Japanese people hope that reciprocity can be established between mainland China and Japan, and joining the convention together would be a very good way forward. And in Asia, there are also other countries that no judgments recognition is possible without treaty relationship. For example, Indonesia and Thailand, they follow the Dutch system that a treaty is required to establish reciprocity. And other countries listed up here are also restrictive with regard to the recognition and enforcement of judgments. So having treaties, again, for these countries will be very helpful, and it's meaningful to have an international instruments in this region. So to sum up, the Judgment Convention is an important and significant milestone, and bridging between regions and countries is a task that is attributed to the Judgment Convention, and it is particularly meaningful in the Asia Pacific. And in addition to that, because the Hague Conference does a great work of monitoring and assisting contracting states, we can hope that once becoming a member state, we can have great support of the Permanent Bureau. So to sum up, the Judgments Convention and Choice of Court Convention are important two-tier system to enhance circulation of judgments, and we hope that we can see further developments in this respect. So thank you very much for your attention.
Thank you very much. Arigatou gozaimasu. Thank you very much. Thank you, Professor Nishitani. Thank you very much for this great discussion. And so, ladies and gentlemen, the next topic for discussion is joining the 2019 Judgments Convention, experiences of contracting parties. We'll have Professor Fernando Diaz Simoes at the podium to share the insights with us. Thank you. Welcome.
Thank you very much. Secretary General of the Hague Conference, Dr. Christoph Bernasconi, dear guests and speakers, ladies and gentlemen, good afternoon. I would like to start by thanking the organizing committee for the kind invitation to attend this world-class event. It's really a privilege to have the opportunity to see some, I'm not going to call them old friends, but long-time friends and also to make some new friends. On a personal level, it's also a pleasure to be back in the fragrant harbor. I lived and worked in China for 11 years, first at the University of Macau and later at the Chinese University of Hong Kong across the harbor. And even though I returned to my home country 1 year ago, Hong Kong still feels like home. So thank you very much for this opportunity to address you today. My task today has been greatly facilitated by the previous speakers who offered very clear and rich overviews of the convention, of the convention's main features and the process that led to its entry into force. So I'll just share a few reflections focusing on the Portuguese experience in joining the convention. As you all already know, the Judgments Convention entered into force on the 1st of September, following the accession of the European Union, excluding Denmark, and the ratification by Ukraine. It has also been mentioned already that Uruguay ratified on the same day the convention, and it will enter into force regarding that country next year. Several countries have already signed the convention, but not yet ratified. It has already been mentioned before, such as Costa Rica, Israel, Russia, and the United States. The convention might well become a near universal instrument for the recognition and enforcement of court judgments, and that's the hope that it will function in in a way that is somehow similar to what the New York Convention does for arbitral awards. And we all know that it is basically the most successful convention created under the aegis of the United Nations. So we can only hope that in a few years' time, we will be saying the same thing about this convention. For the time being, there are other conventions addressing similar topics, but they are geographically limited. That's what happens with the Brussels I recast regulation, which is limited to EU member states, and the Lugano Convention, which is limited to European Free Trade Association member states. So the hope is that the Judgments Convention will have a larger geographical scope. The European Union is a contracting party rather than individual EU member states. So my home country, Portugal, is bound as a result of the accession by the European Union. The European Union did not adopt uniform implementing provisions for now. If member states decide eventually to implement some individual rules, this might undermine uniformity. The convention, it has also been said, represents the minimum requirements for recognition and enforcement of foreign judgments. So it does not prevent the recognition and enforcement under national law, bilateral, regional, or other international instruments. So it has also been said that it provides a floor rather than a ceiling. As a result of that, European Union member states are likely to continue to use the Brussels regime for enforcing intra-EU judgments because of the relative advantages of that regime, and the conventions give way provisions for pre-existing and conflicting instruments. So the Brussels I regulation has been said to provide for the free circulation of judgments. Just like the free circulation of people, goods, and services, this is something that sometimes we Europeans take for granted. We can only hope that in the future there will be a free circulation of judgments on a global scale. There is something to learn from the European experience because, as we all know, the European Union is an economic but also a legal and judicial integration process. So the convention applies only to the recognition and enforcement of judgments, but as mentioned previously by my fellow panelists, it does not address the jurisdiction of a court to hear disputes until the enforcement stage, which might increase the risk of parallel proceedings in different jurisdictions. In this regard, the Brussels regime, the Lugano Convention, and the Hague Convention on Choice of Court Agreements are so-called double conventions that address both jurisdiction and the recognition and enforcement of judgments thereby reducing the likelihood of parallel proceedings. We have also heard that the Judgments project has begun provisional work that may eventually lead to a new instrument addressing jurisdiction in cross-border litigation. So there's still plenty of work to do. Turning to the enforcement of foreign judgments in the Portuguese context, of course, most intra-EU judgments are recognized and enforced under the Brussels I recast regulation. This regulation, Regulation 1215 from 2012 of the European Parliament and of the Council on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters, is the basis for the recognition and enforcement of intra-European Union judgments in the Portuguese courts. Other judgments are recognized and enforced under the Portuguese Civil Code without prejudice to the provisions of international treaties or conventions. We have signed several treaties, for instance, with Angola in 1995, with Cape Verde in 2003, with Guinea-Bissau in 1988, with Mozambique in 1990, with Saint Tomé and Príncipe in 1976, and also with Macau in 2001. What all of these jurisdictions have in common is the fact that they have Portuguese as an official language as a result of the fact that they are former colonies of Portugal. So these instruments cover Portugal's most important trading partners, with the exception of Brazil. We don't have a treaty with them. But it covers basically the European Union and other Portuguese-speaking jurisdictions. Portugal, of course, is also a party to the New York Convention on the recognition and enforcement of foreign arbitral awards, which in the last decades has become more and more important, and more foreign awards are being recognized nowadays by the Portuguese courts following the New York Convention. So in the Portuguese context, in Portuguese courts, the ease of securing recognition and enforcement of a foreign judgment will basically depend upon the applicable regime. On the one hand, the judgments that fall under EU regulations or within one of the multilateral or bilateral conventions that I mentioned previously. In this case, the process is generally quite straightforward, with an automatic recognition of decisions in the case of intra-EU judgments, or based on the reciprocity system resulting from bilateral agreements, which tend to guarantee a positive outcome. On the other hand, in the absence of an applicable convention, Portuguese domestic law establishes several cumulative requirements, and these must be demonstrated before the Portuguese courts, which are often unfamiliar with the relevant foreign law, and as a result, proceedings may be slower and more complex. For instance, they may require engaging the services of a local law firm. I now turn to some concluding remarks. For the convention to become the true game changer that we all hope for, it needs to be, of course, ratified by a significantly diverse list of jurisdictions. And when we talk about diversity, of course, Asia Pacific is one of the regions of the world where I hope a lot of that diversity will come from, and a lot of that push forward will come from. On the other hand, a cession by the United States that has already acceded the convention would be a major step, of course, in enlarging the number of jurisdictions. However, in the US, the recognition of foreign judgments is essentially a matter for individual states, not the federal government, and this may raise some domestic implementation issues. We all heard today and also yesterday that the convention has a lot of potential. It has the potential to provide a unified global framework for the recognition and enforcement of court judgments, and thereby reduce costs, increase certainty and predictability, as the keynote speaker also mentioned, promote the better management of transaction and litigation risks, and shorten timeframes for the recognition and enforcement of a judgment in another jurisdiction. We can only hope that with time, It will become sort of a powerful legal app that connects users from across the world. And by users, I mean courts from different jurisdictions, and in the end, people and companies that need to have their rights recognized and enforced abroad. In practice, its smooth application also depends on national judges. One should avoid the so-called homeward trend that sometimes takes place in the application of, for instance, the Convention on the International Sale of Goods. According to Article 20 of the Convention, judges should strive for a uniform interpretation of the Convention. Events such as this one, I'm sure, are vital to to promote and disseminate best practices in this regard. The Hague Conference is, of course, to be congratulated for organizing this event and for the successful entry into force of the Convention. When I left law school 20 years ago, private international law was one of my favorite topics. I found it intellectually challenging, theoretically fascinating, but I wondered, honestly, at the time, what practical relevance did it have? How many cases would I face in real life having to do with recognition and enforcement of a foreign award or judgment? Nowadays, any lawyer needs to be a bit of a private international lawyer. Of course, globalization, as we know, is ever increasing. I count, of course, on the HCCH to nurture the new generation of private international lawyers. Roughly 100 years ago, Portuguese poet Fernando Pessoa famously stated, "My homeland is the Portuguese language." I believe that on this day and age, we should all state, "My homeland is international law," and we should all be fluent in that language. Thank you so much for your attention.
Thank you very much, Professor Simoes. Thank you. And welcome back in Hong Kong, by the way. Enjoy your time in your second hometown. So, ladies and gentlemen, following Professor Simoes' speech, we will now invite Dr. Jacek Kozikowski to join us at the podium. So Dr. Kozikowski will be talking on the same topic. Welcome.
Thank you very much, Secretary General Bernasconi, distinguished guests and speakers, ladies and gentlemen. It's a great honor for me here to speak to you today and celebrate together the 130th anniversary of the Hague Conference on Private International Law. It's really a great pleasure, and I think due to the wonderful organization of this event, and also by the regional office, by Professor Yun Chao and the wonderful team, we all feel like home. So thank you very much for this experience. Today, I'll draw a few lines about the experiences of my country, of Poland, on the joining the convention. Probably in the first, in the first touch, you might think, why would a Polish and a Portuguese gentlemen discuss during the Asian Pacific Week about our experiences? And I assure you that, having the best football players in the world with Cristiano Ronaldo from Portugal or Robert Lewandowski, Poland, is not that reason. But there are a few other. Poland, I think there are a few good reasons why to discuss the joining of this convention and instrument of this kind by the country which I come from. First of all, we are a member of the European Union, so one of the first member states of the convention. As was mentioned by Fernando, we have the privilege of joining the convention, not directly as a country, but as a member state. Second reason for having Poland as an interesting example is the level of development of my country. So as you can see, we have, being a member of the European Union for almost 20 years, we received a high income economy status in 2009. We're developed market status. But on the other hand, if you look on what kind of forces are driving the market, you will realize that these are mainly small and mid-sized corporations, so that we are still an underdog within the very mighty economies of the European Union, and our perspective might be slightly different than our more wealthier Western neighbors, such as Germany. And I think a third reason why I think Polish example will be an added value to today's conference is our geographical location. As you will see on the map, we are the last party and the last country of the European Union to the east, and actually the most immediate border of Ukraine. And as you know, Poland became a corridor for humanitarian, military, material assistance toward Ukraine. Over 6 million Ukrainians fled toward Poland since the war started. And that includes not only refugees, but also businesses, also high net individuals, and also their assets. So you better look on the Polish case in the next years to come when the Ukraine reconstruction project starts, because it is possible that a number of enforcement will concern the Ukrainian assets that are located in Poland. So what is our perspective since 1990s when Poland started transitioning from a centrally governed economy into free market economy? Of course, for the first 20 or 30 years, we were trying as a country to incentivize foreign investments. So we've been acceding to any potential conventions, international instruments that will bring a strong message to foreign investors. We are a safe country, and whatever judgments of an arbitral award will happen outside of Poland, you will be able to enforce it. So that's why we entered a number of bilateral investment treaties on the investment side, the WTO instruments, but also the New York Convention. ICSID is one of the exceptions. We are the only European Union country which is not a party to the ICSID Convention. On the other hand, because the early 90s was a little bit shaky in terms of the rule of law, a number of big international arbitrations were sent outside of the country. That situation is changing right now. So if you can see, we have two strong arbitral institutions and arbitration institutions in Poland, which are highly promoted. And we have a growing community of small, mid-sized enterprises, which are more and more interested in expanding their operation abroad. So as much as I would say that the last 20 years was about how to secure situation on foreign investors in Poland, right now it is how to ensure that Polish companies who want to make their first steps in their internationalization process can actually ensure a smooth dispute resolution outside of the country and its enforcement. So, of course, I'm in a private practice. I'm not a representative of government. I more speak to my clients than to governmental officials, in fact. But when I talk to my clients and when I see barriers that they communicate to me in terms of their international growth, they mainly mention the transactional costs and costs of disputes. When you hear about, in a very concrete manner, the hourly rates of lawyers in Poland will be something between $100 to $200 per hour, whereas if you go outside in many countries, that will be 3, 4, or even 10 times more. So for companies which have still a very unstable cash flow, which don't want to go through a usual path of building a strong operation in Poland and then expanding, but would like to start their business from expansion, these costs actually become a big barrier, right? And for that sake, I think the Hague Convention become a perfect instrument. I've heard it somewhere in the corridor that it could be a sort of middle-class instrument or mid-sized corporations instrument, and it seems to be true from my perspective. Also, comparing costs of pursuing litigation versus international arbitration, I could say that the costs, from the mere fact that you were a counsel in arbitration, you used to charge 3 times more, and for companies who are expanding into markets of Africa, of the Latin America, it is very important that the pool of experts who can handle their case is sufficiently big. So the competitiveness of prices on the legal market are also high. If you look on the Polish internal perspective, it's quite similar to the one that was mentioned by Fernando, because most of the European countries, apart from their domestic perspective of their domestic regulations, they are to a large extent depending on the Brussels I recap. I think you mentioned that it's sort of self-understanding that this instrument is widely used within the European community, and I think that's really the case. The situation for countries like Poland changes at the moment when our companies go outside. In terms of our perspective inside, it seems, bearing in mind our business relationships with our key business partners, which are mainly in the EU, that the existing instruments could be sufficient. How the enforcement works in few words in Poland, well, we have separate regimes, one for EU member states. That's mainly the repetition of what you can read in the regulations that are implemented by the European Union. You have no exequatur procedure. You have immediate title for enforcement of any judgment that is issued by the EU. And in terms of non-EU countries, you have the automatic recognition system. In disputed areas, you might still, request the court to determine whether the issue is enforceable, unenforced, or non-enforced, recognizable or non-recognizable, based on the certain exclusion provisions that I'll mention in a second. But in general, the system is, divided between the recognition and enforcement of foreign awards. Quite similar to the Hague Convention. I think the basic requirements are very simple. You bring in the judgment must be proved as final. You translate it. In case of any judgments, by default, you have to prove that you served any documents to the other party at the place of origin. In terms of grounds for non-recognition, also quite similar, I would say, compared with the Hague Convention. So if judgments are non-binding, if they're against the public order. So I would say here there are not much differences of both perspectives. Right before my departure, I took a look on the statistics of the regional court in Warsaw, who is dealing with most of our enforcement cases. And it seems that in the first half of 2023, there were over 337 cases. I'm not good in math, but I believe that I can draw a conclusion that there could be around 600 to 700 of that cases per year. So it's quite a lot already. Nevertheless, the majority of them, again, are in the relationships with the other European Union member states. Polish courts, including Supreme Court, heard a number of cases, including enforcement and recognition of foreign awards. I wouldn't surprise you that these issues are quite universal. When Justice Gao today mentioned the issue of whether the documentation was properly served to the other party at the place of origin, or whether the other party has sufficient time to read it and to propose its defense line. This is also a number of cases in which are heard on a regular basis by the Polish court. Similarly to some of the provisions in the convention, the issue of the punitive damages that come with judgments from the United States. They've been also a couple of times heard by the Polish Supreme Court, and they were simply recognized in part. So in that part that does not touch upon the punitive damages. From the comparative perspective, you see that, if you do things on the national level, there are very little compromises that you have to find because you are deciding on your own system. And in that terms, probably out of the available instruments of European and international law, Polish national system will be one of the most liberal. We don't have specific exclusions from the scope, etc. It's very natural that if it goes to meeting interest of many stakeholders, you have to build upon these exceptions. Poland is subject to a number of bilateral treaties, mainly on the legal assistance. But I think wonderful slide from Dr. Bernasconi from yesterday showing how many of them you have to achieve in order for the world to be governed by a sort of quasi-multilateral system that could apply to enforcement of foreign judgments. Two examples, one from Ukraine, and I think this is really to what we're encountering right now. I can tell you from the Warsaw perspective, since the war started, we have employed 5 Ukrainian attorneys, really top-notch lawyers who are working on the Polish, Ukrainian, and Ukrainian rest of the world cases on a daily basis. And these are mainly business-related cases. So I can see that The instrument, we have the instrument in place between Poland and Ukraine, but I think a number of countries which will be taking place, hopefully, in the reconstruction process do not have such instruments with Ukraine. So also when I analyze and I try to think, what is the meaning behind this composition of the first member states, the European Union and the Ukraine? I think Ukraine is in a position exactly right now to show, we have done everything possible for, you to feel safe in terms of enforcement of judgments that are rendered with regard to Ukraine. One interesting story behind the Polish-Hong Kong Treaty and in general Polish-Hong Kong-China relationship, there was a case a few years ago when the Polish Supreme Court rejected the recognition and enforcement of a judgment that was rendered here in Hong Kong because the plaintiff wanted to pursue that based on the Polish-China bilateral treaty. This bilateral treaty was entered into force in the 80s. So at that time, Hong Kong was still not Chinese. When the Hong Kong was given back, the bilateral investment treaty was not extended to the territory of Hong Kong, therefore dismissed. So the instruments that are connecting Hong Kong with Poland with regard to civil enforcement of civil judgments are not in place right now. If Hong Kong will decide to join the convention, then that will be the first instruments to follow. So what are the prospects for Poland? But again, I was trying to bring an added value of a business, of Polish business, what would help them. And I think the perspective of SMEs, the small, mid-size, and micro corporations is one of the most value that I can see and most true need of the economies that are on the rise to limit the cost and speed up proceedings for both dispute resolution and enforcement. Of course, from the regional perspective, if the UK joins the convention, that could also help in the relationships concerning after Brexit. And the fact that again, it's about cost optimization, the fact that you don't have to engage in benchmarking local laws in every jurisdiction in which you plan your trade is a wonderful story. What are the challenges? I think they are universal, but there will be a panel on that, so I don't want to spend too much time on that. But I would say that due to the nature of a multilateral instrument, the number of concessions that had to be made during the negotiation process and a number of carve-outs in terms of scope could be one of the challenges. Second, of course, a number of countries which will join ultimately the convention. And I see also our role in promoting of that instrument, hence today's and this week's event. We strongly promote the possibility of this convention to flourish. Interim measures do not fall within that scope, and I think for especially smaller companies with limited cash flow, with limited possibilities to withstand the lengthy court proceedings, interim measures could be of a help to mainly to keep cash flow. Basically, that's one of the main concerns of small and mid-sized businesses. And from the internal Polish perspective, bearing in mind our current business relations with other countries, there are many alternatives to the Hague Convention. But if we think about Poland in the next years to come, there are no alternatives. So we have to take and we have to believe in the Hague Convention and help to promote it in those regions in which the economic interest of our country stays. For good or for worse, they are in Africa and Latin America for Poland. So these are definitely the places in which we'll be very much focusing. So again, thank you very much for your attention. I hope that it brought you a little bit of knowledge of what we think about it in our part of the world, Eastern Europe, Poland. Thank you.
Thank you. Thank you very much, Dr. Kozikowski. Please have a seat back on the stage. Thank you very much. And now, ladies and gentlemen, we thank every one of our panelists. Just gave us a very good discussion. And now it's time for our Q&A session. So we suggest everybody to make the most of this opportunity and just feel free to raise your hand and to direct your question to any of our panelists on the stage. Or Justice Goddard with us online. Any questions? Any raising hands? All right, okay, let's hand the microphone to our guest there.
Okay. As far as I understand, it seems everybody is quite positive for the 2019 Judgments Convention here. The question I want to put to the panel and also maybe to the Secretary General is, as far as I know, I have conducted this study of comparison between the 2019 Judgments Convention and the 1971 Judgments Convention. I think academically, the 1971 Judgment Convention to me is actually very, very good already. But the 1971 Judgment Convention, not successful, proved to be, right? I know that many people say that there are many reasons there, right? But here, could I know or say, according to your understanding, what are the real essential differences between the 2019 Judgments Convention and the 1971 Judgments Convention that can probably make this time successful? Thank you very much.
Thank you for your question. So who's this question for?
Anyone? Anyone?
All right, okay.
I'd be very happy to comment on it because there's one critical difference that I think needs to be emphasized, and that is that the 1971 convention required bilateralization between each pair of states that would recognize and enforce each other's judgments. So if you think about it, if you had, say, 30 contracting states, one of them needed to take 29 bilateral actions, next one 28, next one 27, next one 26. You have hundreds and hundreds of bilateral actions that would have been required to create the sort of network effect that makes an instrument of this kind truly valuable. Whereas we were very conscious of that problem in designing the 2019 Judgments Convention. And if a state joins, as now Uruguay will be in a year, it immediately enters into treaty relations with every other contracting state unless some state positively chooses not to have that relationship. So you need to take one treaty action and you form a relationship with every other contracting state under this instrument. So that's one enormously practical, important difference. Then there's the fact that I think we're all, we learned from the text of the 1971 convention, and there are some provisions that are very similar. But we have done our best also to learn from the experience of other very successful instruments like the New York Convention, from the European instruments, which have been very successful in that environment, to craft a modern and I hope future-proofed instrument that will work well for the modern cross-border trade and investment environment. So a practical difference about its network effects and how states enter into relationships, which I think will be the critical practical difference, but also a more modern, a more future-proofed text.
Thank you very much, Justice Goddard. Please, Dr. Bernasconi.
Thank you very much. And maybe just to follow up, because I, of course, wholeheartedly agree with what Justice Goddard just said. I think another fundamental difference lies in the group of people who negotiated these conventions. 2019 is also a game changer because for the first time, really the world community largely represented, not uniformly represented. We're still missing Africa to a large extent, but I think for the first time we had a fairly well, largely represented world community giving itself an instrument that would facilitate the circulation of judgments, and all the negotiations were based on consensus. I cannot stress this enough. I think the 2019 convention is much more of a common understanding of what is acceptable at the global level than what 1971 was. And I think that's important to keep in mind as well.
Thank you, Dr. Bernasconi, for adding your views onto this question. So probably Professor Nishitani, would you like to add your words?
Thank you very much. All the points I wanted to make have been mentioned already. So
Thank you very much. And Professor Simoes?
Well, if I may add, maybe it's not a very technical answer, but I would say maybe we are not being overly optimistic. We are not really taking any leap of faith. But at the moment when we witness war back in European soil, I think it's more important than ever to build mutual trust through legal instruments. And so it's more important than ever to build bridges between nations, not to burn them.
Thank you very much for your. So, Dr. Kozikowski, would you like to share your views onto this question?
No, thank you. I think the previous answers already exhausted the topic, so thank you.
Thank you very much. All right, so we have time for one more question. Please, gentlemen.
Good afternoon. Well, of course, congratulations to the panel for the very concise and very informative presentation. Anyway, I was just wondering, the 1970 Judgments Convention is considered superseded already by the 2019 Judges Convention. Am I correct in saying that? Professor
Nishitani?
Nishita, please. Am I correct in saying that we have abandoned the 1970 Judges Convention and superseded by this 2019 Judgment Convention?
Professor Nishitani, please. Thank you very much. I would say yes.
I was just wondering, were there state parties to that acceded to the 1970 Judgments Convention? Yeah, if you know.
I'm sorry, I should have.
Sorry, can you repeat your question, please?
Were there state parties, who acceded to the 1970 Judgment Convention?
I understand your question. So the 2019 convention says that previous international agreements are respected, and in that respect, if certain states are both parties to the 1971 convention already. Thank you very much. Yeah, thank you. So then parties to the 1971 conventions are Albania, Cyprus, the Netherlands, and Portugal. So Netherlands and Portugal are already parties to the 2019 convention.
Because they acceded to the 1970 convention.
Yes.
Okay. I was just
no,
asking.
not because of that, but they are party to the 2019 convention.
They had to re-accede, so to speak, insofar as the 2019 Judgment Convention is concerned.
Yes, within these countries, actually, Cyprus, Netherlands, and Portugal, among them, that's covered by the Brussels 1bis regulation, and Kuwait and Albania are outside of that. So maybe there is a narrow scope where the 1971 convention can be applied. It's not excluded, but there are exceptions. Yeah. Thank you.
One more, may I just ask? Because the Judgment Convention is related to transnational litigation. So, and most of the transnational litigation conventions pertain to judicial documents pertaining to civil and commercial matters. But apparently, the 2019 Judgment Convention expanded this. Am I correct in saying that? That it is not only limited to civil or commercial matters, but also to other matters?
The 2019 Judgments Convention is a convention in civil and commercial matters. And what I said was that in 2005 Choice of Court Convention does not cover consumer or employment contracts. So it's commercial matters.
So it's still limited to civil and commercial matters?
Yes.
Okay, Thank you.
Thank you very much for your question. And thank you, Professor Nishitani, for addressing this question. Thank you very much. And let's give it up for our panelists. Thank you. Thank you for a great panel discussion. Thank you very much, ladies and gentlemen. So now it's another coffee break time. Oh, yes. Let's have a virtual goodbye with Justice Goddard. Thank you for joining us this wonderful afternoon. Thank you for your time. We'll see you in person, of course, in the future. Thank you very much. So, ladies and gentlemen, now it's time for us to have some hot tea, hot coffee, or even just some hot air. Thank you so much. Never underestimate the power of Hong Kong's air conditioners, okay? All right, so I'll see you in half an hour. So we'll continue with our session at 4:30. Please enjoy your coffee break. Thank you very much. And don't forget to bring with you your belongings. Thank you very much, and I'll see you in a bit. Welcome back, everybody. Welcome back to the last session of today on the entry into force of the 2019 Judgments Convention. And we have a distinguished panel join us on stage for this session. Let's welcome Professor Zheng Xinhuo, Professor of Law of the School of International Law at the China University of Political Science and Law, COPL. Welcome to the stage. Let's welcome Ms. Peggy Ao Young, Principal Government Counsel of the Department of Justice of the Government of Hong Kong SAR. Welcome to stage. Let's welcome Judge Su Jin Cho, Judge of Seoul Western District Court of Korea. Welcome to join the panel. And also let's welcome Professor Kosuke Takeshita, Professor of the Graduate School of Law of the Hitotsubashi University of Japan. Welcome to join the discussion. Okay, please have a seat. And we will now firstly invite Professor Zheng Xinhuo to the podium to share the thoughts on benefits and challenges of the Judgments Convention. Please.
Distinguished Secretary General Bernasconi, dear colleagues, I think it's my great honor and pleasure to be invited to take part in this great event. And the title of our session is the benefits and challenge of the Hague Judgment Convention. Well, I think that the benefits of this convention obviously is enormous, because the world is witnessing a precedented challenge against this kind of background. And so I think that if the convention can be ratified by most countries in the world, it will provide a great impetus to the globalization. However, the challenge is also enormous, because as long as these most countries ratify the convention, it can fulfill its accomplishment. Otherwise, the convention is good, it's there. However, it can hardly realize its purpose. So my topic today is to talk about the Chinese law, whether China is ready to ratify the convention or not. As you know that just this month, the Standing Committee of the National People's Congress revised the civil procedure law. And as a matter of fact, these amendments mainly touches upon Part 4, that is special provisions for civil proceedings of cases involving foreign element, which suggests that China has substantively reformed its rules for international civil litigation. And some of the articles, I think, has a very close relationship with the Hague Judgment Convention. In general, the amendment covers the following issues. First, it expands the jurisdiction of Chinese courts over international civil and commercial dispute to a considerable degree. For example, it allowed the parties to choose a Chinese law to hear the dispute in written agreement. Even the places to which it has material connection are not located in a PRC. Moreover, it adds two categories of international civil litigation within the exclusive jurisdiction of the Chinese courts. Second, it made headways to improve the rules to solve the conflict of international civil jurisdiction. For example, it contains the rules for the Chinese court to deal with the parallel litigation and incorporates forum nonconvenience, which is based upon and simultaneously develops the rules originally contained in judicial interpretation on the civil procedure law issued by Supreme People's Court. Third, it updates the means to service abroad and taking of evidence abroad to boost the efficiency of international civil litigation. Fourth, and more importantly, it systematically improved the rules for the recognition and enforcement of foreign judgment, which fills a legal lacuna led by the previous versions of civil procedure law. So now, I'd like to focus on the rules on the recognition and enforcement of foreign judgment. According to these articles, we can find that first, it enhanced the transparency of judicial review in China, because these 2013 amendment states that the application for recognition enforcement of foreign judgment should be granted unless otherwise expressly provided in Article 299. Consequently, the amendment spelled out the situations where the recognition enforcement should be refused. And it should be stressed that it provides situations where the jurisdictions of foreign courts would not be recognized by the Chinese court. In the second place, the amendments provides that a Chinese court may suspend proceedings if the application for recognizing and enforcing a foreign judgment on same subject matter between the same parties is submitted to it, which is an effort to stabilize the relevant legal relationship and to meet expectations of the parties. So now let me emphasize the articles on the recognition enforcement of foreign judgment contained in the latest amendment of the Civil Procedure Law. First is Article 300, which focuses on refusal of recognition enforcement. It provides that after review, the People's Court of the PRC should make the rulings to refuse the recognition enforcement if one of the following situations occurs. First, foreign jurisdiction lacks jurisdiction over the dispute under Article 301 of the CPL. Second, the defendant was not summoned, or though summoned, he was not given the reasonable opportunity to claim and debate, or defendant without litigation capacity was not properly represented in the proceedings. Third, the judgment or ruling was obtained by fraud. Fourth, a People's Court of PRC has rendered judgment on ruling on the same dispute, or has recognized and enforced the judgment on ruling on the same dispute given by a court of another state. Fifth, recognition enforcement would be incompatible with the basic principles of law, national sovereignty, and the social public interest of the PRC. So this article provides an exhaustive ground for the refusal of recognition enforcement of foreign judgment, which means that a foreign judgment will be recognized and enforced if none of these grounds occurs. Article 301 concerns the situations where a foreign court lacks jurisdiction over dispute. It provides that a foreign court lacks jurisdiction if one of the following situations occurs. First, the foreign court lacks jurisdiction over the dispute under the law of its own. Second, the rule of exclusive jurisdiction provided by this law was violated. And third, the jurisdiction of foreign court is contrary to the exclusive choice of forum agreement by the parties. Therefore, the amendment uses a negative list to confine indirect jurisdiction, which is different from the Hague Judgment Convention. The advantage of Chinese law is that the jurisdiction of foreign court not covered by this negative list should be recognized, which I think will expand the indirect jurisdiction recognized by the Chinese law. And Article 302 it deals with the res judicata. It provides that the People's Court of PRC may suspend proceedings if the application for recognizing and enforcing foreign judgment on the same subject matter between the same parties is submitted to it. If the requirement for recognizing a foreign judgment are not met prescribed by this law, the People's Court of PRC should make a ruling to reject the application and resumes the proceedings. If requirements for recognizing a foreign judgment are met prescribed by law, the People's Court of PRC should make a ruling to recognize it and issue an extraditor to enforce it in case the enforcement is necessary. So, based upon these articles, let me emphasize the possibilities of China's joining the Hague Judgment Convention after this CPL's latest amendment. One of the most important aims of the 2013 amendment of CPL is to systematically establish a legal regime of the recognition and enforcement of foreign judgment. to a considerable degree, I think the aim has fulfilled. What's more, a careful reading of the articles in amendments relating to the recognition and enforcement of foreign judgments suggests that the Hague Judgment Convention plays a visible influence on this amendment. For example, Article 300 and 301 of the amendment of CPL incorporates some articles in Article 7 of the Hague Judgment Convention. It follows that the legal obstacles that prevent China from joining the Hague Convention have been removed to a certain degree. Consequently, I believe that after this amendment, China is taking a step towards the accession to the convention. However, a number of difficulties still remains ahead. After all, the conflicts between the Hague Convention and Chinese civil procedure law still exist. So I believe that more legal reforms on the recognition and enforcement of foreign judgment are needed before China would be ready to join the Hague Conventions. As you know that so far China has not signed the convention, so I think that before the ratification of Hague Judge Conventions, I think that a previous step is that the National Standing Committee of the National People's Congress, China, ratified the 2005 Choice of Forum Convention before China can be ready to join the Hague Judgment Convention. Of course, as a Chinese scholars of private international law, I'm expecting that China may taking a bigger step towards the accession to these Hague Conventions. Thank you.
Thank you very much. Please return to your seat. Thank you. And now let's move on to the next topic on regional perspectives. We would like to invite Ms. Peggy Ao Young to the podium. Welcome.
Dr. Bernasconi, Professor Hua, the Honorable Judge Chu, Professor Takashita, distinguished guests, ladies and gentlemen, good afternoon. I'm most grateful to have this opportunity to join this distinguished panel and share with you some observations on the 2019 Judgments Convention from the Hong Kong SAR perspective. Hong Kong has all along been a strong supporter of the Hague Conference. We have fond memories of our years of friendship and close cooperation with the Hague Conference for decades. Speaking of the Judgments Convention in particular, just 2 months after its conclusion in July 2019, Hong Kong hosted the first global conference on the convention in September that year. More than 200 participants from 18 jurisdictions were addressed by over 15 speakers who are practicing and academic lawyers, judges, and officials from the Asia region, Europe, and Latin America, who had participated in the negotiation of this groundbreaking new convention. And 4 years later, the Hague Conference has chosen to hold its Asia-Pacific Summit in Hong Kong, celebrating its 130th anniversary, and also more importantly, marking the entry into force of the Judgments Convention on the 1st of September. Hong Kong is most privileged to have taken an active part in and have contributed to the deliberations of the Judgments Project and subsequently the Convention. With the support of the central government, the informal working groups 2 and 4 under the Judgments Project took place in Hong Kong in February 2019. We are most pleased that these meetings were contributed to the final conclusion of the convention. And on a more personal note, I was very privileged to have participated in the special commission meetings of the project itself, as well as the diplomatic session leading to the conclusion of the convention. And the reason for my participation in these sessions of the project is indeed the crux of my sharing today. A couple of years back, I was part of a team in the Department of Justice working on a new arrangement between Hong Kong and our motherland, the mainland China, on reciprocal recognition of and enforcement of judgments in civil and commercial matters. And at this point, one may ask, why is there such a need for an arrangement on REJ, the short for reciprocal enforcement of judgments between Hong Kong and the mainland China? My short answer is one country, two systems. Hong Kong, as a special administrative region, is part of the People's Republic of China. And at the very same time, thanks to the innovative principle of one country, two systems, the legal system of Hong Kong is distinct from that of the mainland China. Hong Kong maintains its common law system that is constitutional guaranteed under the Basic Law of the Hong Kong SAR, a piece of national laws of the PRC. Under Article 2 of the Basic Law, the Hong Kong SAR exercises high degree of autonomy and enjoys independent judicial power, including the power of final adjudication. Hong Kong courts adjudicate cases independently and are separate from the mainland courts. Given that Hong Kong's legal system is different from that of the mainland China, judgments in civil and commercial matters made by Hong Kong courts would not automatically be enforceable in other parts of China, and vice versa. Judgments made by mainland courts would not automatically be enforceable in Hong Kong. We therefore need to build a bridge between the legal systems of mainland and Hong Kong so that judgments made in relation to civil and commercial matters could travel between the two jurisdictions and become mutually enforceable. In seeking to construct this bridge, we are mindful of learning the experience from around the world. Where else could we find a more reliable and useful reference than the Judgments Project? The Hague Conference itself has abundant experience in bridging different legal systems. In fact, Hong Kong has drawn inspiration not only from the Judgments Project, but also the Choice of Court Convention concluded years before. Having made reference to the Choice of Court Convention, Hong Kong and mainland China in 2006 entered into an arrangement providing for REJ in cases where parties have entered into exclusive choice of court agreements. Substantially similar to the Choice of Court Convention, the choice of court arrangement between Hong Kong and the mainland has a very specific, if not limited, scope of application. It only applies to money judgments made by the Hong Kong court or the mainland court arising from a dispute of a commercial contract where the parties have agreed in writing, designated either the Hong Kong court or the mainland court to have exclusive jurisdiction to determine any dispute arising from the contract. With increasingly closer interactions and cooperation between Hong Kong and the mainland China in terms of trade, as well as other socio-economic aspects, the choice of court arrangement alone is no longer able to address the needs. As a result, there have been calls from time to time in the community to widen the scope for REJ between the two jurisdictions. In formulating a more comprehensive REJ regime, reference has been drawn to the then draft versions of the Judgments Convention. Indeed, the REJ arrangement was concluded around half a year before the conclusion of the convention. And so, what does the arrangement do? While the Judgments Convention applies to all contracting parties, the REJ arrangement is only applicable between Hong Kong and the mainland. Having said that, the REJ arrangement shares substantially similar objectives with that of the convention. In particular, the arrangement seeks to facilitate REJ between Hong Kong and the mainland, noting that such enhanced legal cooperation between the two jurisdictions would provide greater predictability and certainty to the parties, and hence better protection of parties' rights and interests. In specific terms, the REJ arrangement reduces the need for relitigation of the same disputes in both places, offering enhanced protection to the parties' interest and also enhancing the competitiveness of Hong Kong as a regional international legal and dispute resolution center. Allow me to now outline the key features of the REJ arrangement, which are substantially similar to the convention. I will touch upon these 4 dimensions. Firstly, on scope. The arrangement applies to matters which are considered to be civil and commercial in nature under both Hong Kong and the mainland law. Non-judicial proceedings and judicial proceedings relating to administrative or regulatory matters would be excluded. By way of non-exhaustive examples, the following matters are excluded from the arrangement. First, judicial review cases, and secondly, cases brought by regulatory authorities. For example, proceedings seeking disqualification orders against directors of listed companies brought by the Securities and Futures Commission would be excluded. This is consistent with the approach adopted in the Judgments Convention that, among other matters, revenue, customs, or administrative matters are excluded. The second dimension, on definition of judgments. As far as the arrangement is concerned, in case of the mainland, any judgment, ruling, conciliatory statements, however they are labeled, would be covered. But rulings on preservation measures would be excluded. And in the case of Hong Kong, any judgment, order, again, however they are labeled, would be covered. But anti-suit injunction and interim relief would be excluded. This approach is also consistent with that adopted in the Judgments Convention that an interim measure of protection is not a judgment for the purposes of the Convention, and judicial statements approved by a court of a contracting state, and judicial statements which are enforceable in the same manner as a judgment of the state of origin shall be enforced under the Convention in the same manner as a judgment. The third dimension I'd like to cover is on enforceability. The REJ arrangement employs substantially the same concept of enforceability embodied in the Convention, Article 4 of which provides that a judgment shall be recognized only if it has effect in the state of origin, and shall be enforced only if it is enforceable in the state of origin. Under the REJ arrangement, only legally enforceable judgments made in one place could be enforced in the other place. In terms of drafting, the arrangement adopts the notion of effective judgments, which is in substance no different from enforceable judgments. The definition of effective judgments and the relevant mechanisms for determining the same, as provided for in the arrangement, has taken into account the following important features. Firstly, under Hong Kong law, a judgment on appeal remains legally enforceable unless it is subject to a court's order for stay of execution. And secondly, under mainland law, in very general terms, legally effective judgments could be subject to a retrial under the operation of the trial supervision procedures as provided for under the civil procedure law of the PRC. Translating into more specific terms, as far as mainland judgments are concerned, the REJ arrangement provides that the following judgments are legally enforceable. First of all, any judgment of the second instance, and secondly, any judgment of the first instance from which no appeal is allowed, or the time limit for appeal has expired and no such appeal has been filed. And thirdly, any judgment of these 2 categories made in accordance with the procedure for trial supervision. In respect of Hong Kong judgments, The arrangement covers legally enforceable judgments given by all the relevant civil and commercial courts in Hong Kong, and including some specific tribunals, like the Labour Tribunal and the Smallest Claims Tribunals. This is a scope wider than that covered under the choice of court arrangement between Hong Kong and the mainland in 2006. The fourth dimension, grounds for refusal. The REJ arrangement sets out in clear terms the grounds under which enforcement of a relevant judgment would be refused. These grounds are substantially similar to those provided under the Judgments Convention. Such refusal grounds are provided to, among others, observe natural justice, give effect to res judicata, and safeguard against judgments obtained by fraud or judgments that are contrary to public policy. I will now turn to discuss the features of the REJ arrangement which are different from the Convention. Firstly, the Convention in its Chapter 2 establishes the basis for recognition and enforcement of a judgment in the form of jurisdictional filters against which the judgment from the state of origin is to be assessed by the state where recognition and enforcement is sought. In order for a judgment to be eligible for recognition and enforcement, it must satisfy the connections with the state of origin as identified in Article 5. In other words, only judgments satisfying the jurisdictional filters provided in Chapter 2 of the Convention would be eligible for circulation under the Convention. The REJ arrangement, unlike the Convention, provides various jurisdictional grounds which are in substance similar to those under the Convention, and yet such grounds do not operate as determining whether the arrangement is applicable in the first place. Rather, the grounds serve as grounds for refusal. In other words, if the relevant judgment does not satisfy the jurisdictional grounds set out in the arrangement, the requested court must refuse to recognize or enforce the judgment in the requested place. One may ask why the arrangement has taken a different approach. My short answer would again be one country, two systems. Given Hong Kong is part of China, the reciprocal enforcement we are looking at would be the enforcement within one country. The overarching principle in devising an REJ mechanism between Hong Kong and the mainland China are to respect the differences between the respective legal systems of the two places and to maximize the facilitation for REJ and legal cooperation as far as practicable. Anchoring as such important principles, jurisdictional grounds are adopted as refusal grounds rather than as filters to determine eligibility of a judgment in the first place. In terms of legal implications, under the REJ arrangement, the party against whom enforcement is sought would bear the burden of proof to prove to the satisfaction of the requested court that the relevant judgment does not satisfy the jurisdictional grounds, and hence, enforcement of the judgment should be refused. While in contrast, under the Convention, it would presumably be the party seeking to enforce a judgment to prove that the subject judgment is eligible for circulation in the very first place. In other words, the judgment is not jurisdictionally filtered out. The second notable difference is the coverage of certain IP matters in the REJ arrangement, in contrast to the outright exclusion of IP matters from the Judgments Convention. Specifically, the arrangement provides a definition of IP rights, mirroring the types of such rights as stipulated under the TRIPS, with an additional reference to plant variety rights as provided for under the respective laws of Hong Kong and the mainland. The specific applicable scope of the arrangement on judgments involving IP rights is summarized as follows. Firstly, judgments ruling on all contractual disputes involving IP rights are covered. Secondly, judgments ruling on tortious claim for infringement of IP rights are also covered, except for infringement of invention patents and utility models in the mainland, and standard patents and short-term patents in Hong Kong. Thirdly, judgments ruling on the license fee rate of standard essential patents in both the mainland and Hong Kong are excluded. Lastly, a ruling on the validity, establishment, or subsistence of IP rights is not recognized or enforced under the arrangement. This approach in relation to the coverage of judgments on IP rights adopted in the arrangement reflects the commonly recognized territoriality principle applicable to IP rights on the one hand, and the very practical needs and circumstances of Hong Kong and the mainland China on the other hand. This major breakthrough makes Hong Kong the very first jurisdiction to have an arrangement with the mainland on REJ with such a wide coverage, reflecting the unique advantages of one country, two systems. Looking ahead, the REJ arrangement would be implemented by way of local legislation in Hong Kong and in the mainland by way of judicial interpretation to be promulgated by the Supreme People's Court. The Department of Justice is actively working to bring about its early implementation so that a comprehensive REJ mechanism could come into place between Hong Kong and the mainland China the soonest. And ladies and gentlemen, despite the differences between the legal system of Hong Kong and the mainland under one country, two system, the REJ arrangement, modeling on the Hague Judgments Convention, is nothing but an excellent model for effectively bridging the two legal systems within one country, and more importantly, transforming the differences into distinctive and practical advantages. The arrangement is a vivid testimony of the vitality of one country, two systems. Looking ahead, Hong Kong will continue to support the Hague Conference by actively participating in and we are eagerly looking forward to working closely with the Hague Conference in organizing capacity building and experience sharing activities for the stakeholders, be they government officials, judges, experts, academics, so on and so forth, in the Asia-Pacific region and beyond. On this note, may I once again thank the Hague Conference for giving me this opportunity to present in this panel, and I wish you a fruitful summit. Thank you very much.
Thank you very much. Thank you, Ms. Ouyang, for this very impressive address. Thank you very much for joining us today. So we'd like to welcome Judge Sujin Cho to the podium as well. Judge Cho will also be sharing the insights on the topic of regional perspectives. Welcome to the podium.
Thank you. Distinguished guests and participants and my fellow panelists, ladies and gentlemen, good evening. I'm Sujin Cho, a judge from South Korea. I'd like to extend my gratitude to the organizers for the invitation. It's my great honor and pleasure to have us to stand here and share some stories of Korean judiciary. So, yeah. Korea has joined the HCCH conventions. Korea has joined and ratified 4 HCCH conventions so far. Among them, the Service Convention and the Evidence Convention have played very important roles in Korean courts. However, Korea has not signed the Choice of Court Convention and the Judgments Convention yet. So I'm going to share some experiences of enforcement and recognition and enforcement of Korean judiciary. Okay, sorry. Yeah, sorry. For Korea, losses that go beyond borders are common, but the number of recognition and enforcement of foreign judgment cases not that many. Oh, sorry. This is not. Sorry. But this is from the last year. What happened? So, I should have checked. Sorry. Maybe I should go on without the presentation, PowerPoint presentation. Sorry, I'm very sorry about that. For Korea, losses that go beyond borders are common, but the number of recognition and enforcement of foreign judgment cases not that many. In the past 5 years, there have been approximately 55 recognition and enforcement of foreign judgment cases in Korea. This number is based on my research, and there may be some cases missing. So it is very few compared to that of Poland before. So among these cases, almost half of them were related to the judgments of the United States courts, followed by judgments of Japanese courts at around 15%. Others involve judgments of courts in 16 different countries. Under the Civil Procedure Act of Korea, we have 5 elements for a foreign judgments to be recognized. First, the foreign court must have international jurisdiction. Second, the defendant must have received written complaint by proper service that does not violate their right to defense. Third, the recognition of foreign judgments must not be against the public policy. Fourth, there should be a reasonable expectation that judgments of the Korean courts will be reciprocally recognized in the respective foreign jurisdiction. Furthermore, the foreign judgment must be final and conclusive. When compared to the current system, the most important advantage of the Judgments Convention would be predictability. Currently, it is not easy to determine whether a foreign judgment would be recognized in Korea. Sometimes even judges have different opinions when dealing with this issue. In 3 cases out of 55, judgments of courts were reversed on appeal in High Court or Supreme Court. Currently, the laws of other countries should be examined, and reciprocity can sometimes be a difficult issue. Joining this Judgments Convention will make this work much more predictable, substantially mitigating the costs incurred due to uncertainty. The Judgments Convention would also expand the arena for communication between contracting states, enhancing predictability. Second, with the Judgments Convention, we could expect the judgments of Korean courts to be more widely recognized in other contracting states. This would be the most significant benefit of the Judgments Convention for Korea's sake. Recently, Korean courts have been widening the scope of recognizing foreign judgments. I'd like to introduce 2 recent Supreme Court decisions that show this trend very briefly. So the first one is a decision of last year. In this case, Hawaiian court ordered the defendant to pay triple the amount of actual damages due to unfair competition. The plaintiff requested recognition and enforcement of the judgments in Korea. Thank you. And the defendant argued that this Hawaiian judgment is against the public policy as it is ordering compensation exceeding the actual damage. The Seoul High Court denied the recognition of threefold compensation for a similar reason with the argument of the defendant. However, the Supreme Court of Korea declared that although there is no law in Korea that allows compensation that exceeds actual damage in this matter, this Hawaiian judgment should be recognized, considering that threefold compensation is actually allowed by the same fair trade law in other occasions. And the next decision is about the scope of proper service for a foreign judgment to be recognized. According to the previous case law, of Korean Supreme Court, supplementary service was not considered as a proper service when dealing with recognition of foreign judgment cases. But in this decision, Supreme Court widened the scope of proper service by including supplementary service as long as certain conditions are met, changing its previous case law. In both decisions, the Supreme Court of Korea mentioned the stability and predictability of the international transaction order or international trust in legal procedures of Korea. So the Korean Supreme Court is trying to pursue predictability and acquire international trust. As the Korean judiciary is trying to establish the International Maritime and Commercial Court in Korea, garnering broader recognition of Korean court judgments in other countries is very important. And joining the Judgments Convention will help the Korean judiciary reach the goal. So, what is hindering us from embracing this important and remarkable convention? I can outline two challenges here. Firstly, the appeal of this convention would be even greater if more countries had already joined. The United States and EU has already signed the convention, but the positions of other Asia-Pacific countries hold considerable importance for Korea, given its active economic engagement in the region. Although a relatively small number of countries have signed the Judgments Convention, I believe that many more will join very soon, amplifying the benefits of the convention. Second, Korea might need to make efforts to prevent other countries from exempting Korea with notification under Article 29. In practice, the example of the Child Abduction Convention is worth noting, as some important countries have not joined or have made reservations to the convention. The benefit of the convention is limited in practice. Also, we need to decide whether we need to make reservations in the Judgments Convention carefully. It is no doubt that the Judgments Convention is one of the most important achievements of the HCCH. It is also very special for Korea, as many Korean experts, including some judges and professors, could participate from the early stage of discussion and contributed to the outcome. It appears that there is already a consensus among Korean experts that we need to sign the Judgments Convention. With several major economic partners having already signed the Judgments Convention, I believe Korea will also sign it in the near future. Lastly, the remaining tasks of the jurisdiction project are like the final pieces of the puzzle, and I believe that once these pieces are put into one place, the Judgments Convention will shine even brighter. I wish for the success of the jurisdiction project. With this, I conclude my presentation. Thank you very much, and I'm very sorry for the PowerPoint presentation mistake.
Thank you very much, Judge Cho. Thank you. Even without the PowerPoint, your sharing is still incredibly fascinating. Thank you very much. And of course, we look forward to more of your valuable insights during the Q&A session. Thank you very much. Okay, ladies and gentlemen, the next speaker, Professor Keisuke Takeshita, will be discussing Looking Forward, the Jurisdiction Project. Welcome to the podium.
Distinguished guests, ladies and gentlemen, good afternoon. I am Keisuke Takeshita, Professor of Private International Law at Hitotsubashi University in Japan. It is my great honor to be here as a speaker of such a wonderful conference. I would like to express my sincere gratitude to the Secretary General, Dr. Berlusconi, and all the organizers of this conference. And I also thank all people, participants, staffs, who contribute enormously to this conference. Today, the title of my speech is Looking Forward. I will talk about the jurisdiction project. In other words, the possible future instrument dealing with matters related to jurisdiction. However, before starting the substantive part of my presentation, I would like to look back to the past by showing you a slide. Het internationale Recht in Japan. I'm not sure my Dutch pronunciation is good or not. This is Tobias Asser's handwritten memo. I found it for my academic research at the Netherlands National Archive in The Hague. This year, we celebrate the 113th anniversary of HCCH. Anniversary celebrations always remind us of the historical links with the predecessors. I also thank to Tobias Asser and other predecessors for their continuous efforts, and at the same time, as the chair of the working group on jurisdiction, I feel a sense of obligation to take over the efforts. Let's move on to the substantive part of my speech. As I told you, I will make a speech on the jurisdiction project. First, I would like to introduce briefly the working group on jurisdiction and its mandate. And next, as this session is about the 2019 Judgments Convention, I would like to explain the linkage between the Judgments Convention and the possible future instrument. Needless to say, analysis of the linkage is based on the current draft of the new convention attached to the preliminary document number 2 of February 2023, a document for the CGAP 2023. Therefore, the rules might be changed through the future discussion in the working group. After that, I will introduce to you briefly the current status of the discussion in the working group and conclude my speech with some remarks. As usual, I need to make it clear that today I will make a speech in my pure personal capacity, and what I talk today is based on my personal view and does not represent the view of the chair of the working group on jurisdiction, nor the view of the Japanese government. First, I will introduce to you the overview of the jurisdiction project. To let you know the project, it would be good to recall the mandate of the working group on jurisdiction. CGAP 2021 established the working group and mandated it to develop draft provisions on matters related to jurisdiction in civil or commercial matters, including rules for concurrent proceedings, to further inform policy considerations and decisions in relation to the scope and type of any new instrument. CGAP also mandated the working group to proceed in an inclusive and holistic manner with an initial focus on developing binding rules for concurrent proceedings, that is, parallel proceedings and the proceedings of related actions or claims. In accordance with this mandate, the working group started to discuss the initial focus of concurrent proceedings, in particular, the rules of pure parallel proceedings, that is, the proceedings between the same parties on the same subject matter. So far, 4 meetings were held. The first and second meetings were held online in October 2021 and in February 2022 during the pandemic. Through the discussion, the working group figured out the basic structure of the binding rules for parallel proceedings. In the third and fourth meeting, which were held in hybrid style, the working group discussed how to put the basic structure into the provisions of the draft text. The fifth meeting will be held next week at Buenos Aires. In my understanding, the jurisdiction project tries to make a new instrument and add it to the existing instruments to complete the whole structure or whole package of the rules of international jurisdiction of courts and recognition and enforcement of foreign judgments, as if to fill in the missing pieces of the jigsaw puzzle. The original objective of the judgments project was to harmonize the rules of international jurisdiction of courts and recognition and enforcement of foreign judgments through one single convention. But after 2001, it was scaled down to focus only on exclusive choice of court agreement, and the 2005 Choice of Court Convention was adopted. However, HCCH did not stop its effort to complete the whole structure of the rules of both fields as far as possible. And as a result, the 2019 Judgments Convention was adopted as the second piece of the puzzle. Currently, the jurisdiction project is exploring the third piece of the whole structure. Although the name of the project has changed to the jurisdiction project, the possible new convention would be the sister convention of the 2005 Choice of Court Convention and the Judgments Convention. As the main topic of this session is, again, as I mentioned, the 2019 Judgments Convention, I would like to explain a little bit more the close linkage between the Judgments Convention and the possible future instrument. It seems to me that the new instrument would solve some issues in the field of recognition and enforcement of foreign judgments, which the Judgments Convention would unintentionally leave to the future discussion. As it is often pointed out, 2019 Judgments Convention established the minimum standards for the recognition and enforcement of foreign judgments, or floor of the recognition and enforcement of foreign judgments. Therefore, according to Article 15 of the Convention, contracting states may recognize and enforce foreign judgments under national law, which is pointed out as the adoption of the favor negotiatis principle. Only Article 6 provides international obligation to deny recognition and enforcement of foreign judgments if a judgment on rights in immovable property situated in a contracting state was rendered by a court of another contracting state. As a result, it might still happen that a judgment of a contracting state arising from the exercise of the exorbitant jurisdiction might be recognized and enforced in another contracting state. The famous example might be the recognition and enforcement of judgments within the EU member states. Among the EU member states, recognition and enforcement of judgments will be dealt with by the Brussels 1A regulation, and as the regulation also provides the jurisdictional rules, the judgments of a court of an EU member state will be recognized and enforced without checking the ground of jurisdiction. And courts of EU member states still use the grounds of jurisdiction under national law when the defendant is not domiciled in a EU member state. As a result, an EU member state will recognize and enforce the judgment by a court of another EU member state exercise jurisdiction, which might be exorbitant from a viewpoint of the defendant. Of course, from the viewpoint of the member state of the court rendering the judgment, the exercise of jurisdiction would not be exorbitant. And I never intend to criticize the EU rules itself. It can happen in other countries also. However, I would like to show you the possibility of recognition and enforcement of a judgment arising from the exercise of the exorbitant jurisdiction from a certain perspective. Therefore, it would be an appropriate question whether it is appropriate to always allow contracting states to recognize and enforce foreign judgments under national law. The situation would be different from the arbitral hours and the settlement agreement resulting from mediation, as both are based on party autonomy. For these dispute resolutions, it is reasonable to adopt the so-called pro-enforcement principle or pro-enforcement bias. However, concerning judgments, as they are not necessarily based on party autonomy, it can happen that recognition and enforcement of a foreign judgment cause problems for some parties. It can be said that these issues should be solved to a certain extent. Of course, this is a matter or problem in the field of recognition and enforcement of foreign judgments, but at the same time, it closely relates to it can be regarded as a problem of jurisdiction. The new instrument would solve this issue to a certain extent. In my understanding, one of the roles of the new convention is to realize the adjudication of a dispute in an appropriate forum of a state. In particular, a court which would render judgment eligible for recognition and enforcement under the Judgments Convention. Tentative rules for parallel proceedings in Article 3 of a draft of the provisions on parallel proceedings for future discussion in the preliminary document number 2 of February 2023 gives priority to the proceedings of a court of a contracting state which have a connection under the new convention. The connections under the new convention should be in harmony with the basis for recognition and enforcement under Article 5 and 6 of the Judgments Convention. For example, Company A in state K bought a machine from a company B in state J. But because of the defects of the machine, which was handed over to the company A at its factory in state K, company A could not use the machine as it planned, and therefore it could not hand over its products to another company and needed to pay the penalty of breach of contract. As a result, company A sued company B for seeking compensation of damage based on the contract in a court of state K, and company B sued company A for seeking the declaration of non-liability in a court of state J. In this situation, under Article 3 of the drafting text, as the state K would have a contractual connection which is the same as the basis of Article 5.1g of the Judgments Convention, which was explained by the Professor Nishitani. And state J does not seem to have a connection. And as a result, court of state J shall suspend or dismiss its proceedings. By providing these rules, the new convention tries to promote the application of the Judgment Convention by enhancing the possibility of the adjudication in a court of a contracting state, whose judgment would be eligible for recognition and enforcement under the Judgments Convention. Also, the new convention tries to avoid the possibility of the adjudication in an inappropriate forum from the viewpoint of the defendant, probably, and to reduce the possibility of the adjudication in a court whose grounds of jurisdiction might be exorbitant from certain perspective. In this way, the new instrument would support the application of the Judgments Convention, and therefore it can be said that the two instruments would have close linkage. Let's move on to the next. I will briefly explain the current status of the jurisdiction project. As I mentioned, the working group started with the discussion on the initial focus, that is the concurrent proceedings, which means the pure parallel proceedings and the proceedings of related actions or claims. Still, the working group is discussing the rules for pure parallel proceedings. I myself believe the working group has been making steady progress, but it might seem for some people that the progress in the discussion is relatively slow. It seems that the main international obligation under the new convention is to suspend or dismiss the proceedings, as I showed you an example in the previous section. The working group needs to discuss how to provide the situation in which in which a court of the contracting state should suspend or dismiss the proceedings. As the Secretary General, Dr. Berlusconi, mentioned in his speech so many times, discussion in HCCH should proceed on a consensus basis. It always needs a certain period of time to reach consensus. Because of the difference of the legal culture, it needs a certain period of time to compromise different thoughts of the members. It is a difficult task, but as the predecessors engaged in the previous HCCH projects did, the members of the working group, including the chair, should continue the collaborative effort with certain patience. This is the current status of the discussion in the working group. It seems to me that there are some key points for the future discussion. The first point is that the minimum standard for the rules of concurrent proceedings should be clarified. Faced with the diversity of thoughts, it would be important to find common grounds Though I always respect the diversity and the difference of thoughts, such common grounds would be the basis of the minimum standard of the rules for concurrent proceedings. Of course, the working group should make efforts to go beyond the minimum standards by finding out more and more common grounds. But first, it would be necessary to clarify what would be the minimum standard and to reach consensus on the rules of minimum standard. In order to reaching the consensus on the rules of minimum standard, it is necessary to find a way to have common grounds which will be the basis of the minimum standard. For this purpose, it seems to me that simplicity of the rules would be important. When we consider the common grounds, the grounds should be shared commonly, not only among the members of the working group, but also among many people, including judges, lawyers, practicing lawyers, and in particular, private parties to the disputes who should benefit from the new instrument. For this purpose, complicated provisions would not be appropriate. In addition, it would be necessary to give appropriate attention to the private party's interest. It might be evident, but I would like to stress the importance of the party's interest. To protect the party's interest, for example, giving parties the certain initiatives in the application of the convention might be one thing that should be considered further. At the beginning of my speech, I talked about the historical links with the predecessors. But as the structure of today's conference topics, in particular session 4, I believe, the structure shows we also need to recognize the links with the future generations. The judgment project is not only for the current world, but also for the future world. Certain sense of inclusiveness might be the key factor for the success of the jurisdiction project. At least respecting inclusiveness, the project should be open to the current world, but with constructive imagination, we should find the common grounds that would be or should be shared with the future generations. Now I conclude my presentation. Thank you very much for your kind attention. Thank you.
And also, we thank you very much for your valuable contribution to the panel. Thank you very much, Professor Takashita. Now, ladies and gentlemen, we come to the valuable time for the Q&A session. So please feel free if you have any questions for any of our panelists on stage. Now on stage, we have Professor Huo, Judge Cho, and Professor Takashita. And also for our guests on Zoom, you can just simply type your questions into the chat box, and we will relay the questions to our panelists on stage. So, any questions? Any hands? All right, can we give the microphone to this gentleman? Thank you.
Thank you so much for speaking at our events, and your insights and perspectives were truly valuable. And we all know the significance of the Judgments Conventions as well as the jurisdiction project. And just like in case of the choice of court convention, it's directly related to the number of its contracting parties. And the ratification of these instruments will contribute to the construction of an effective and predictable international system of mutual recognition and enforcement of foreign judgments. And the question I want to raise is about how to wider promotion the conventions And do you have anything to share about the synergy between the Judgments Convention and the Choice of Court Convention, as well as the Jurisdiction Project? Thank you so much in advance.
Okay, all right. So who would you like to direct this question to? Okay, maybe we can start with Judge Cho.
It's a very good question, but it's also a very hard question to answer. As Korea is not a party to the Choice of Court Convention, I haven't studied the relationship between them, and I believe as far as I know, joining both convention is very important. So I believe they will be mutually beneficial to each other. that's what I know.
Thank you very much for answering the question. Now, we would like to hear from probably Professor He. Would you like to share your views?
Thank you for your question. Well, I think that there exists a kind of relationship among these two, between these two conventions and probably the future convention on jurisdiction. And it's of course, I think that harmonize the jurisdictional rules and the rules on recognition enforcement of foreign judgments are one of the major aims of the HCCH, because if this aim can be fulfilled, I think that it will be a great contribution to the global governance in the civil and commercial matters, especially in this particular moment. As you know, that the globalization is witnessing unprecedented challenges because of geopolitical reasons. So I think that, yeah, they are very important, but these are very difficult aims to fulfill because the countries are very different in terms of the rules on jurisdictional rules and recognition enforcement for judgment. So it seemed to me that as a first step, the 2005 Choice of Forum Convention was adopted, because this is the, I think, a particular area where the countries are easier to reach compromise. But you can see that even the convention has been adopted more than 18 years ago, but the number of the contracting party is still limited. China has signed this convention, but so far the Standing Committee of National People's Congress has not ratified this convention. As for the Hague Judgment Convention, China has not signed yet. So you can see on the one hand, it seems that China seems to be actively involved in the creation of these Hague Conventions to show its support to adopt the adoption of these conventions. But out of complicated reasons, China is still not ready to ratify this convention. And to me, that the jurisdiction, the future conventions on the jurisdiction rules would be more difficult to be compromised, because the countries are very different in this aspect, and every country nowadays seems to expand its jurisdiction. Therefore, the compromises should be more difficult to be compromised. But anyway, I think that harmonized jurisdictional rules is one of the greatest dreams of the international law community. If this field can be harmonized, I think that it will benefit the whole world. So of course, though it's difficult, we still should be optimistic and be patient about this future convention. Thank you.
Thank you for your thorough input into this question. Now, Professor Takashita, would you like to add some views?
Well, in my presentation, in the last part, I stressed the importance of the parties' interest. the world, it is truly, it might be truly difficult to, for some states to accept or ratify or conclude those conventions. However, we should keep in mind that the international order is, in my personal view, not for the countries, but for the private persons, business persons, of course, consumers, employees. It would be necessary to explain to private persons, yeah, these conventions are truly essential for protecting your rights. And in this way, if people in the world would wish to have such conventions, the situation might be changed. This is my personal view. Thank you.
Thank you very much. Thank you for addressing this question. Now, do we have any more questions from the audience here in person? Okay, I see a hand. Can we pass the microphone to this gentleman, please? Thank you.
Okay, thank you very much. I have a question to the Japanese professor. We are talking about the judgment jurisdiction project, right? And you also mentioned the current status of this project, right? And you mentioned a few elements, or say a few factors that should be taken into account when we are drafting provisions for that project, especially for concurrent proceedings, which of course is a indispensable part for this project, right? My question to you is, according to my memory, actually in 2002, in the interim text, right, there was, to me, a very good compromise between foreign nonconvenience and respondents. I'm wondering how much we are still working on that way, or are we totally inventing something that is quite different from the old draft provisions in the 2002 interim text? That is the first question. The second question is, to me, is the forum nonconvenience is an ingrained doctrine in the common law, right? And respondents is also a very welcomed, well-established doctrine in the European Union, which are mostly composed by civil law countries. If the 2002 interim text version for parallel proceedings couldn't be adopted, I'm wondering whether we really have another way to go. Thank you very much.
All right, Professor Takeshita, shall we start from the first question?
Before answering to the question, maybe interim test might be 2001. And for answering your question, probably one thing I should say, as the mandate of the CGAP clearly directed us, we need, as a working group, need to initially focus on the parallel proceedings and the related actions of claim, that is the concurrent proceedings. In my understanding, 2001 interim text rule for respondents or forum non-convenience, this is in the whole structure of the rules. 2001 text has rules for direct jurisdiction also. And we changed the way. First, we will discuss the concurrent proceedings as the initial focus. And after that, we will discuss other matters. And therefore, we started with the concurrent proceedings. Therefore, the rules would a little bit changed in my understanding, and it would be necessary for the success of the jurisdiction project. Unfortunately, in my understanding, if, for example, as the chair of the working group, if I make a draft text very similar to the 2001 interim text, it might not be acceptable for some states, I believe. And therefore, we changed the way of discussion and find a way forward. And therefore, in my understanding, 2001 interim text rule cannot directly in the new convention. First, we focus on the concurrent proceedings, and after that, I'm not sure how far we will discuss the rules matters related to jurisdiction. But in this way, the way of discussion is quite different, and it affects the contents of the draft provisions. This might be the answer to the both questions, I believe. And if I need to reply to your question more, could you please elaborate your question again?
Thank you very much. Thank you. I think we have some time for one last question. Okay, this lady, please.
Thank you. Good afternoon. Firstly, I'd like to commend everyone behind the HCCH for your efforts towards making justice more accessible to everyone, one of which, of course, is through the 2019 Judgment Convention. But I think that success will not be complete if not many countries or all countries will accede to the convention. So my question is, I'm just curious, at this point in time, what are the most common reservations of the countries based on your discussions for not acceding yet to the 2019 Judgment Convention?
So who would you like to give this question to?
Anyone may answer.
Professor Ho?
I think this question, I think the most the people that has the authority to answer this question is our
Dr. Bernasconi, thank you.
Thank you for this loaded question, I guess. But I guess we have to step back and first of all remind ourselves that it is actually remarkable that the Judgments Convention has already entered into force. When you look at the overall picture, it takes just amongst the core conventions, so what we call the core conventions are basically the most successful or most recent important conventions of the HCCH, it has taken on average more than 6 years, well over 6 years, for conventions to enter into force. The fact that the Judgments Convention, a game changer, a really difficult convention to develop, to bring states together, has entered into force in just over 4 years, is actually a very positive sign. So I really would like to give a positive spin to this discussion as opposed to say, you know, why are states wondering? No, we are on a good spin. I think there is positive momentum with, 6 more states that have signed it. We know that there are others that are actively looking into it. At the end of the day, it's really a question of priorities amongst governments and administrations as to, what comes first. The global political setting is not the easiest. There are other priorities, certainly. But again, I take this as a good sign, as a very positive, encouraging sign that we already have the convention in force, including with such an important trading bloc as the EU. So all of the EU, with the exception of Denmark, is already in. Now we have Ukraine, and then in Latin America we have a positive spin from Uruguay. When I heard before that, if China were to now ratify the Choice of Court Convention, that would be a first step towards possibly then ratifying judgments. That's also positive. So I take a lot of comfort from the fact that these discussions are ongoing, and we just have to give time time and let things grow and develop, and it will come. Because I think and this is maybe in response to a previous question, we started with this very ambitious double convention on jurisdiction and recognition and enforcement in the past, and we all came to realize this is not going to work. It's just too ambitious. And then we scaled down and looked at the lowest hanging fruit, which was choice of court, really. And we have, in my view, an excellent, quite easy and straightforward exclusive choice of court convention that I really think states should sign and ratify tomorrow morning, because I don't see the downsides in this convention. It's just about legal certainty and predictability in business-to-business deals, and in particular, it provides a real alternative to arbitration for small and mid-sized companies. Nothing against arbitration, but it can be very expensive, and so for small and mid-sized enterprises, the choice of court is really a very practical alternative to take into account. Then on the ladder of all these projects, we took really a huge step with the Judgments Convention. Now I have to be a bit more careful as to how I phrase this, in particular also in front of our dear chair of the jurisdiction group. I think we can take one more step on this ladder, certainly for parallel proceedings and concurrent actions. I am very optimistic that we can do this, also because the chair is so hardworking and is so committed to this, together with the group. Jurisdiction, we'll see. I still see a lot of challenges there. I'm not saying it's impossible, but that's really the most difficult final step to take. So there is a lot on the table. Again, let's give time to time, take it step by step, but in particular, states should take the benefits of all the work that has been, and time and resources that have been invested in these choice of court and judgments conventions, and give the time also to the working group to continue and finish its work in a meaningful way. We are not really rushed by time. We should take into consideration the fact that, yes, the world has changed. As the organization grows, it is more and more difficult also to find consensus. That is a challenge of this growing organization that we all endorse. But it also means that we have to be a bit more patient when it comes to develop these instruments. But all in all, I'm very optimistic.
Well, thank you, Dr. Bernasconi. And I believe Dr. Bernasconi well answered your question, right? And we can clearly see a better and greater job that the HCCH is trying to do. And that makes a perfect ending of today's conference. Thank you very much. And let's give it up for our best and perfect panel. Thank you. Thank you, every and each one of you. Thank you for today's conference. Thank you very much. Now, ladies and gentlemen, we have to come to an end of today's conference, and we hope you all enjoyed today's discussions and the presentations. It's all very valuable. And before you leave, please make sure you collect all your belongings with you. And for those applying for Law Society CPD points, please sign the list at the reception. And for those joining tomorrow's conference, please remember to bring your lanyard to expedite the registration process. And of course, we would like to inform the speakers and guests who've been invited to tonight's VIP dinner that a coach has been arranged to take you to the venue. So please gather at the roundabout on the ground floor. So please, you can take the lift to floor G, and our student ambassadors will be waiting for you there. Thank you very much. And we look forward to seeing all of you again tomorrow. Thank you very much.